Did you know that recent rulings have brought significant clarifications to the Negotiable Instruments Act, or NI Act? The Supreme Court and various high courts have been instrumental in this process, focusing particularly on Section 138 and related provisions. One of the key areas of emphasis has been the standard of proof required under Section 139 of the NI Act. The courts have affirmed that a preponderance of probabilities is the standard to be met. They've also clarified that certified copies of income tax returns can serve as evidence to demonstrate a lack of financial capacity in check dishonor cases. Further, the courts have underscored the sanctity of agreements to compound offenses, stating that convictions cannot override such agreements made between parties. And when it comes to vicarious liability, under Section 141 NI Act, the Supreme Court has outlined specific criteria. A person becomes liable only if they are in charge of and responsible for the company's business during the time of the check offense. These rulings have added a layer of clarity to some of the key provisions of the NI Act. But that's not all. The courts have also addressed more nuanced issues within the NI Act. For instance, they've clarified that Order No. 3 Rule 3 of the Civil Procedure Code does not apply to Section 138 complaints of the NI Act. This means that a compromise, once recorded, cannot be withdrawn. The courts have also redefined victim under Section 2 of the Criminal Procedure Code. In the context of the NI Act, it refers specifically to complainants in check dishonor cases. On the topic of third-party prosecutions, the rulings are clear. Only the payee or the holder in due course can file a complaint under Section 138. No third party can claim this right. They've also addressed the compensatory aspect of sentencing, emphasizing that compensation should be proportionate to the check amount, not exceeding twice its value. Lastly, they've clarified that an executive director cannot evade NI Act proceedings just because their name isn't listed in the Registrar of Company Affairs. These judgments have collectively contributed to a more nuanced understanding of the NI Act, shedding light on a range of legal issues.